When Magnus Carlsen up and left the 2022 Sinquefield Cup, explaining later that he felt his opponent Hans Niemann had cheated against him, it rocked the chess world. There is no question, it was the chess story of the year, gravitating to mass media all over, and no publication failed to bring it up in one context or another. I was even asked to speak to an English-spoken radio channel in Dubai to explain what this was all about. Yes, really. Lines were drawn, and some spoke in his favor, innocent until proven guilty, and others against, once a cheat, always a cheat, based on past misdeeds online in his teens. While no end of statistical data was produced by experts on all ends of the spectrum, such as famed anti-cheat expert Ken Regan, which can be seen elsewhere in this channel, or the reams of charts published by chess.com, in the end, that's all it was: statistics and circumstantial evidence. Nothing remotely concrete was ever produced. This is not to side with any point of view. These are simply the facts. Then, months later, on October 20th, 2022, Hans Niemann struck back with the astounding lawsuit for $100 million against chess.com, Magnus Carlsen, the Play Magnus Group, Danny Rensch, and Hikaru Nakamura. I have to admit that Hikaru's name in the lawsuit was really the strangest to me, since while he may be the largest following of any chess streamer bar none, full respect, and made clear that he felt that Niemann likely cheated, it was really no more damning than the rest of the world at large giving their opinions in videos or articles. He was not the one who had accused Niemann. A high-profile pundit for sure, but just a pundit nonetheless. The accusation: unlawfully colluding to blacklist him from the profession to which he has dedicated his life, and sought $100 million in damages from each and every party cited, meaning the lawsuit wasn't for $100 million, it was for $500 million. If one takes the time to read the full decision by the court on the dismissal, you might be quite surprised at the deciding factors that led to the dismissal. One might expect lack of proof, proper evidence, and more, and certainly these are mentioned. But the federal judge decided that she really only had jurisdiction to judge over the antitrust claims in the complaint, and that the other points fell to state law, for which it would be inappropriate for her to override. Unfortunately for Niemann and his legal team, the complaint claiming antitrust injury, which ultimately was the only point actually judged on, was not sustainable. The judge is very clear and detailed in her reasoning, which even a non-lawyer can readily understand. As the Supreme Court has noted repeatedly, Congress enacted the antitrust laws to protect competition, not competitors. Thus, to recover damages under the Clayton Act for violation of either Article 1 or Article 2 of the Sherman Act, a plaintiff must prove the existence of antitrust injury, which is to say injury of the type the antitrust laws were intended to prevent and that flows from that which makes defendant's acts unlawful. This requires that the plaintiff be the target of the anti-competitive activity, not one who has merely suffered indirect, secondary, or remote injury. Niemann fails to plausibly allege an antitrust injury. Again, Niemann defines the competitive chess market as professional chess tournaments and online recreational chess platforms. But Niemann's alleged injuries are not connected to any harm to competition in this market. Indeed, Niemann does not even compete in this market, as he operates neither a professional chess tournament nor an online recreational chess platform. So what it comes down to is that to claim antitrust injury, he would need to show that he was unable to compete in those markets of chess.com, which are organizing tournaments and operating an online chess platform, but being unable to due to monopolistic control of the market. Since he competes as neither, he cannot have suffered an antitrust injury. There was also the question of whether Hans Niemann had suffered injury as a result of his ban from chess.com. And simply put, can they do that with impunity? Again, the claim of monopolization looms to defeat his own complaint. As noted above in the discussion of antitrust injury, Niemann has not plausibly alleged that chess.com's enforcement of its rules, whether fair or not as applied to Niemann, adversely affected competition among the professional chess tournaments and online recreational chess platforms that comprise the competitive chess market. The federal court claimed points 3 and 4 of the original complaint, the ones pertaining to antitrust injury, were dismissed with prejudice, meaning they could never be retried. But other points, slander and libel, fell out of their jurisdiction and can be refiled under state law. And Niemann's attorneys have already stated they plan to pursue the libel and slander claims in state court. So, dismissed, yes, but this is not over.